By now, you've probably heard the news that TPS for Haiti will be terminated effective September 2nd, 2025. In this video, I'm going to briefly discuss what comes next, what you need to know about the termination of TPS, and more importantly, what options you might have to still remain in the United States if you are someone who is going to be losing their TPS status this year. I'm Bianca Jordan. I'm an immigration attorney at Brazen Legal. I work with immigrants all over the world to help them live and work in the United States with lawful permanent resident status, aka a green card. To learn more about me and work with my law firm, you can visit brazenlegal.com. So, in this video, like I said, I want to talk about the end of TPS for Haiti, which is unfortunately not a surprise and it was expected. And now that the news is official, we have to start getting ready for the wind down of what that's going to look like when these people lose their status in September. So, first, the official Federal Register notice announcing the termination of TPS effective September 2nd will be published on Tuesday, July 1st, 2025. And the 60-day transition period will run from July 1st, 2025 to September 2nd, 2025. During that period, people who have a current work permit under TPS will be able to continue to work with that work permit, which will now expire on September 2nd, 2025. Now, what happens after that? So, if you are still in the United States once your TPS ends on September 2nd, then you will be in this country undocumented unless you have another status that you have either switched to or you're in the process of getting. So, for example, let's say that you have TPS that's going to end on September 2nd and you don't qualify for any other immigration benefit and you choose to continue to stay in the United States during that time. You will be here undocumented, which puts you at risk for being placed in removal proceedings, aka deportation. However, if you are eligible for another immigration benefit, for example, asylum, maybe you filed an application for asylum many, many years ago, or maybe you're in the process of filing that application right now. If you have a pending asylum application, you are kind of put in this protected status. It's not really a status, but it's kind of what I like to call a protection bubble where you cannot be deported while your asylum application is pending. Similarly, if you have a pending application for adjustment of status, you are given what's called an authorized period of stay, which again, I like to consider or think of as a little protection bubble where nothing is supposed to happen to you while your application is pending. They cannot really do anything to you until a decision has been made on your case. So if you are somebody who qualifies for something else, then you need to work on filing that other application as soon as possible and consulting with an immigration attorney to really understand what specific options you have for yourself. Now, I'm going to discuss some options that people have, but again, while I am an immigration attorney, I'm not your immigration attorney, and so these are just for general informational purposes only. They're not going to apply to everybody, but if you want to know if it would apply to you, then you're strongly advised to consult with an immigration attorney, either myself or one that you trust near you. So the first benefit that I mentioned, or the first option that I mentioned, is adjustment of status, which means that you're able to get your green card in the United States. Not everybody is going to qualify for this. The only people who qualify for adjustment of status are people who came to the United States legally, either with a visitor's visa or maybe you were paroled. You have an I-94, for example, and you have a visa immediately available to you. The majority of these people happen to be immediate relatives. And in the immigration context, an immediate relative is not what you might think it is. An immediate relative for immigration purposes is somebody who is married to a U.S. citizen, somebody who is the parent of a U.S. citizen, if that U.S. citizen is over the age of 21, or an immediate relative could be someone who is under the age of 21, unmarried, and one of their parents is a U.S. citizen. If that's you, you're an immediate relative if you entered the United States legally, either with a visa, even if it's expired, or parole. Let's say you came in through the Cuba, Haiti, Nicaragua, Venezuela parole program prior to getting TPS. That counts. You're able to adjust your status and get that green card in the United States because you would be considered an immediate relative if you have one of those family relationships that I just mentioned. A brother or sister, not an immediate relative. So if you have a US citizen brother or sister who is filing a green card application on your behalf, they are not an immediate relative. However, if that US citizen brother or sister filed that I-130 for you many, many years ago, and let's say it is now approved and the priority date on that I-130 is current, and you currently still have a lawful entry that has not yet expired, then you might be one of those very rare people who would be able to adjust their status. But these are very case specific and fact specific. So if you think that's you, you might want to discuss this with an immigration attorney. Same thing applies if you are married to a green card holder, or if you are the child of a US citizen but you're married or you're over the age of 21. Those categories of people tend to not be able to adjust their status. However, there are very rare situations that allow those people to do so. So getting a green card in the United States might be an option for many of you. And I speak to somebody every week who is eligible for adjustment of status because they're married to a US citizen, or they have a child who is a US citizen who can petition for them, and they have that lawful entry, whether they came here originally on a visa that has since expired, or they came here undocumented, got TPS, traveled on the TPS, and now they're eligible. And I talk to these people every week, and I know a lot of people are afraid of doing things right now, but you should be more afraid of not having any status in this climate. So if you are someone who is on the verge of losing the status you have and you're eligible to get another one, especially if it's adjustment of status, you need to get on that ASAP, because having nothing to protect you is more dangerous than, and you should be more afraid of that than the fear of possibly getting deported because you did not pursue something that could have protected you from that. So that's going to be the main benefit that a lot of people might qualify for. Another option that people might want to pursue is asylum. Asylum is a little bit controversial because typically, first of all, it's very difficult to get asylum. It's always been very difficult to get asylum. And the reason for that is because there are so many people applying. And if your asylum application is approved, you get a green card, which eventually leads to US citizenship. The United States government loves to gatekeep that. They're not trying to hand out US citizenship to just anybody. In fact, they're trying to take it away from people right now. And so it's very difficult to get asylum. And so the other thing that makes it very difficult for people to get asylum is their travel history. So under international law, you're supposed to apply for asylum at the first country you get to. A lot of people who come to the United States seeking asylum have made pit stops in other countries. If it's simply a pit stop, it's typically not enough to keep you from getting asylum. But if you have lived in another country prior to coming to the United States, if you have worked in another country prior to coming to the United States, if you were offered, lawful permanent status in that other country, whether you took it or not, these are things that could possibly keep you from being able to successfully apply for asylum in the United States. And so that's the challenge that a lot of people have. The other challenge that a lot of people have, and the biggest challenge that I think a lot of people who have temporary protected status who want to apply for asylum will have, is that you're supposed to apply for asylum within a year of entering the United States. There are many people in this country right now who have temporary protected status for Haiti, who have been in the United States since before the earthquake of January 12th, 2010, that led to TPS being given to Haiti in the first place. Can you file an application for asylum late? You can, but it has to be filed within a reasonable period of time. And it's going to be very difficult to show that your 15-year late asylum application is within a reasonable time. Also, if you're filing a late asylum application, there are three exceptions to the 1 year filing deadline. Now, the first one is if you were under the age of 18 when you first came to the United States and you didn't know anything about asylum, you didn't know you had to apply within a year, then you get a pass. Again, if it's done within a reasonable period of time. The second exception is maybe you came into the US as an adult, but when you got here, you were really sick, you were in and out of the hospital, the last thing on your mind was filing for asylum. You might be able to file an asylum application late. And then the last exception is if you can prove that the conditions in your country have changed so much so that if you were if you were to return to your home country, you have a fear of persecution if you were to return, and you have to prove this. And again, this all has to be done within a reasonable time, and you have to accompany it with proof. I know many people, when they file their asylum applications, they simply file the forms, send it off, hope for the best. They want to wait to see if they get a request for evidence or wait until the interview. When you're filing a late asylum application, you do not have that opportunity to do so, not only because you're filing it very late, so you have the onus of showing that they should accept your application late because it's compelling, but also there have been some changes that the Trump administration has implemented as it relates to people applying for asylum in immigration court, where the immigration judge, in their discretion, can look at your filing on its face and decide from there to just preterm it your application without even giving you an opportunity to plead your case in front of them. They can look at the application and say there's no evidence here whatsoever because it's literally just the forms, and so this person must not qualify for asylum. And you don't want that to happen to you. You want to make sure that you have proof of what happened to you, proof of the persecution that you fear that you'll experience if you were to go back to your home country. But for some people who maybe have been in the United States, who came to the United States in the last year or so, they may have a better chance at applying for asylum. And more importantly, it's important to understand that an application for asylum does not guarantee that that application will ultimately be approved. I want to say in April of this year, if I remember reading that about 80 something percent of asylum applications were denied in April. Very, very difficult to get asylum in the United States. But for some people, that might be an option. And a pending asylum application, like I said, is something that keeps you from getting deported in the meantime, in between time, and you're able to apply for a work permit. And similarly, if you're applying for adjustment of status, you can also apply for a work permit as well so that you can continue to work in the country legally. Another option that some people might have is changing status. Some people might be able to change status to obtain a student visa, for example. If you've been thinking about attending school, or if you already are in school and you want to continue your education, you might want to look into applying for an F1 visa. The challenge there is that sometimes you're not able to do a change of status from within the United States. Sometimes you might have to leave the United States to go back to your home country to get that. And that would be a challenge for people from Haiti, not only because of the current travel ban that has been implemented against people from Haiti, but also because depending on how long you've been in the United States, how long you were in the United States undocumented, if at all, before you obtain TPS, those things could possibly prevent you from being able to come back if you are subject to grounds of inadmissibility for which you don't qualify for a waiver. Again, another reason why you really want to make sure that you are consulting with an immigration attorney that you trust, who can properly advise you on your specific situation. While I am an immigration attorney and I'm sharing this information, I don't know that the options I'm sharing right now are specifically going to benefit or apply to you without sitting down with you in a consultation, asking you a series of questions, really understanding your entire immigration history and makeup to determine whether these options can best work for you. Another thing to know about this whole process, especially for those of you who aren't an immediate relative, who don't have any family members to petition for you, a common question I'm getting during consultations is, can my employer petition for me? And the answer is it depends, right? And when it comes to immigration, timing is everything. It's all about time. And The majority of the people that I've been speaking with lately who have been asking whether they can try to pursue a visa or an eventual green card through an employer, many of those people would only qualify for an EB3 visa, which currently is taking anywhere from 3.5 to 4 years to go through the whole entire process. And again, you need time. And so if your TPS is ending in the next 60 days, you don't have enough time to pursue a visa like this. And so a lot of people, unfortunately, no longer have the ability to get an employment-based visa from an employer. It's going to very much depend on level of education. If you don't have a master's degree or better, your options are limited to the programs that take a really long time. But again, this is why it's important to meet with an immigration attorney to discuss your specific options, especially because I've been seeing a lot of people lately who have been pushing the EB2 NIW visa, telling a lot of Haitian nationals to apply for them. But a lot of Haitian nationals, unfortunately, don't qualify for these visas for a variety of reasons. And so this is why I'm making this video, so that people can understand what options really do, or what options really are available right now, because unfortunately the scammers are out here. There are a lot of scammers out here just trying to take advantage of vulnerable, anxious, fearful immigrants. And so I want to make sure that you know what's real versus what's fake. But when it comes to deportation, let's say now you don't qualify for any of the options that I just mentioned. And the options I just mentioned are not exhaustive. These are just the most common options that people might have based on the many consultations I've been doing over the last several months. Let's say you don't qualify for any of these things. September 3rd comes around, you no longer have TPS, you eventually find yourself in removal proceedings. What's going to happen? So first of all, it's important for you to understand that deportation for most people is going to be a long process, because there's not enough judges, not enough lawyers to handle all these cases, both for the government as well as representing people. And so your first hearing is going to be a master calendar hearing where the judge just wants to know what's up. I have a separate video on that process, which I will link to this so that you can understand what really happens to you when you are in removal proceedings. And your case is probably not going to get scheduled for another couple of years, just based on the sheer volume of cases that we have in our immigration system right now. And that's actually a good thing, because again, time is your friend here. You want to try to kill as much time as you can in the United States until something else comes along, until maybe you qualify for a green card or something else. Many people's cases right now are being scheduled out until 2029, 2030, even beyond that. And God willing, we get a new administration that is not anti-immigrant, that actually wants to find solutions to help immigrants stay in the United States. And if that happens, you might have a better opportunity to find a solution to stay in the United States. So I know a lot is happening. I know that, TPS for Haiti is ending, and it's devastating for a lot of people who have been here for a very long time. But I always like to say that just because there's not an option to do something today doesn't mean that you might not have an option to stay here tomorrow. Try not to get discouraged. If something sounds too good to be true, it probably is. Make sure you're getting your immigration information from reputable sources like licensed immigration attorneys. And please share this video with anybody in your network who is experiencing this, who has TPS for Haiti, that is about to end, kind of curious about what options they really have. If you have any questions, definitely drop them in the comments. If you're not following already, please be sure to subscribe. Please find me on all social media. I am Brazen Lawyer everywhere, and I will talk to you in the next one. Thanks.